Hello, everyone, and welcome to Uncivil Law, where we learn from the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe to help the channel grow. For today's case, we're dealing with a cat lady. It's Sally Gantes versus City of Loves Park and her 37 cats, which were contained in a home that was not being kept in a particularly sanitary way. So the police thought that Sally here might be in trouble. So they entered her house, not thinking crime, but thinking, maybe she was in distress. What the police found, however, will distress us all. So let's discuss the condition of Sally's house and her 37 cats. Let's get started with this. Kate Jens breeds cats in her home in Loves Park, Illinois. On December the 4th of 2014, she visited her doctor and was told to go to the hospital because of high blood pressure. Later that day, the doctor couldn't locate Gat Jens, so she phoned a neighbor to ask help in finding her. The neighbor called Gat Jens and knocked on her front door but got no response. So yeah, she went to a doctor for some health issues. The doctor's trying to follow up, can't find her, contacts a neighbor. Can you go look for her? Okay, so the next day, Gat Jens is still missing. So the neighbor calls the police and tells them that Gat Jens might be experiencing a medical emergency, which is a reasonable conclusion, right? The defendant, Sergeant Alton, and others went to the home, but could not see anyone inside. They did, however, notice packages on the porch, an unattended garbage, and a full mailbox. So, yeah, the doctor thinks, this person needs medical help. Maybe they went home, there's no response, so this is like more of a community caretaking function kind of thing. So, what the police should be allowed to do is still an issue of some controversy, but this is, the police have some reason to think this person might be in distress. So they're going to enter the house. What they find in the house, yeah. The police went into the home, but they did not get far. After making it in about 10 feet, intense odors forced them back out. Alton described the smell as a mix of urine, feces, and maybe a decomposing body. This sounds like a hoarder. This sounds a lot like a hoarder. Yeah, with the pets and everything, and the house, with the urine and feces. Yeah. So, yeah, the police couldn't make it more than 10 feet into the house until the smell was so strong it was overwhelming. So, yeah, there's issues here. The police then called on the fire department to enter the home with breathing devices. That's how bad it is. Let's get the fire department with the respirators. The department chief arrived first and told him the whole tale. So the fire department approached the door for himself and got a whiff of something that could gag a maggot. So the police officer told the fire chief, here's what it smells like. The fire chief said, I want to go see for myself. The fire chief agrees. So the fire chief thus temporarily condemns the house as not fit for human or animal habitation by placing a placard on the front door that read, condemned. This structure is unsafe and its use or occupancy has been prohibited by code administrator. It shall be unlawful for any person to enter the structure except for the purpose of making required repairs or removal. More firefighters soon entered and went to the home to look for Gat Jens, but instead of Gat Jens, the 37 cats. So, yeah, this is not going great. And we've seen stories of hoarders before, so I fully believe it. The story of the house with the urine and the feces so strong, it gags the professionals. She doesn't notice anymore because she lives in it, which says a lot about her. But yeah, and so the fire chief takes one whiff of it and is like, I determine this house is condemned, which apparently is a thing he has the power to do. So he whips out the condemned sign, puts it right on the door. Condemned. Unfit for human habitation. Yeah, I think we can understand why the fire chief may have thought that was the right way to go here. Based on these events, Gat Jens, who had been in the hospital all along, so she did go to the hospital. Doctor somehow didn't know, but whatever. So Gatchins sues the city. Relevant to this appeal, she alleges the defendants violated her Fourth Amendment rights by entering her home, condemning the home, and seizing the cats. Not for nothing. Not for nothing, but lady, you need help. You need help. I mean, you need help, clearly. So we can analyze whether the police infringe your rights, and we will. But maybe if the police officers can't enter the home, and the fire chief says it would gag a maggot, and basically without blinking an eye, puts condemned on the door, maybe that's a sign you need help. So maybe less with the suing the government, and maybe a recognition I need help. But we're going to go with the suing the government. Okay, so let's discuss this law about, can we enter the house? Can we condemn the house? Can we seize the cats? Okay, let's figure that out. The Fourth Amendment, made applicable to the states, provides for the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. This applies in both criminal and civil contexts. The ultimate touchstone of the Fourth Amendment is reasonableness, but the warrant requirement is subject to certain exceptions. One such exception arises when exigencies make the need of law enforcement so compelling, a warrantless search is objectively reasonable. To determine whether exigency permits a warrantless search, we conduct an objective review, asking whether the government meets its burden to demonstrate that a reasonable officer had a reasonable belief there was a compelling need to act and no time to obtain a warrant. Okay, let's do that. Here, all the parties agree that the government searched the home. Likewise, all the parties agree that they seized the home and seized the cats. So to satisfy the Fourth Amendment, the defendant's warrantless search and seizures need to fall in with an exigency. And the court knows that they did. Each was justified by the exigent circumstances. So, yeah, this was recently the focus of a Supreme Court case, and the court is going to get to citing it in a minute, about where the community caretaking exception applies or doesn't. Now, the Supreme Court, thank God, said there is no community caretaking exception when it applies to the home. Praise be, we didn't need another Fourth Amendment exception. We didn't need another Fourth Amendment exception. So there's no such thing as community caretaking, thank God. But there is exigency. There is exigency. And so there are emergencies in which the government might be allowed to enter. And some of those emergencies might be things we would have considered to be community caretaking. It's just that we're not going to create a new broad community caretaking exception, right? So some of these exigencies might be examples of community caretaking. The Supreme Court just said we're not going to create a new genus called that, right? So whatever minor exceptions there are, we're not creating a rule built around that, right? But the exceptions are still there. And when the situation is so dire, so necessary, so urgent, that we have to act right now. Right now. Okay, let's figure out whether or not that applies. Okay. First, the officer who began by searching the house had an objectively reasonable belief that Gatchins was experiencing a medical emergency. Yeah, the doctor called a neighbor and said, "I'm concerned about your neighbor. You know, they're having some health issues. Can you check on them?" Okay, we'll blow past whether or not that is a HIPAA issue or not, because at the moment I don't care. It doesn't matter. But let's assume it doesn't matter either way. But yeah, so the doctor calls a neighbor and says, "Can you go check on them?" Maybe because they all know each other, so they're kind of friendly. I don't know. But whatever. The doctor says, "Can you go check on your neighbor? I'm worried about them because they have a health issue." And the police and their mail and stuff is not being collected, so they think, well, maybe she's hurt. Maybe she needs help. Yeah. Second, the people who seized the house had an objectively reasonable basis to believe the home posed a safety threat that required immediate action. So, yeah, we searched the house because we were looking for you. We seized the house because we realized this house was unfit for man or beast. And then Animal Services over here, who seizes the cats, believe that the cats are in imminent danger because they could not be cared for in the home. Uh-huh. Yeah. Okay. So when can we enter a home in the first place? Well, in exigent circumstances, also referred to as emergency aid, government may enter a home without a warrant to render assistance or prevent harm to persons or property wherein. The court here notes Justice Kavanaugh, in a recent Supreme Court opinion, offered the following in a concurring, which is not controlling, example. So this is what Kavanaugh had to say. He said, suppose an elderly man is uncharacteristically absent from Sunday church services and repeatedly fails to answer the phone. A concerned relative calls the police and asks the officers to perform a welfare check. 2 officers drive the man's home. They knock and receive no response. May the officers enter? Of course. And that's what Kavanaugh thinks, right, under that set of circumstance. That might qualify as an emergency. And so the court says, this seems pretty parallel, so we're good. Yeah. So next, can we condemn the home? Okay. So once we have searched the home, by getting 10 feet inside and using our nose, we have deduced immediately there's a problem. So we're going to go to full-bore condemnation. We are definitely seizing your house. Do we have reason to seize your house? Yeah, I think so. Okay. The exigent circumstances doctrine allows officers to enter a home without a warrant to address a threat to the safety of law enforcement or the general public, or incidentally, you. The police reported to the fire chief the home was so noxious the police could not bear in going for more than 10 feet. The fire chief then probed the front door himself and smelled a stench that could gag a maggot. These circumstances give Foley a reasonable basis on which to conclude the home's conditions posed an immediate danger to the occupants and the public. Yeah. I've had the misfortune once of being inside a hoarder's house. And it is pretty depressing. I know. It is pretty depressing. Yeah. And you just see, you just see some things. And that this person house was completely unkempt and urine and feces was completely undone. And I believe it. I believe it. And the house, you need help. You need help. This house is not fit for occupation. Yeah, I believe it. Yeah. Lastly, exigent circumstances may justify warrantless seizure of animals when an official believes the animals are in imminent danger. The imminent danger here, the officers, was plain. Gatchin's 37 cats could not be cared for in the home because condemnation prevented Gatchins from entering the home for that purpose. Yeah. Given the situation, the Animal Services officials' warrantless entry and seizure of the cats did not violate the Fourth Amendment. Yeah, also because I'm just going to take a guess and guess that the cats, may not necessarily be the most well cared for, despite the 37 of them. So animal control over here is seems okay to me. Yeah, I'm good. Gatchins argues in rebuttal that regardless of whether Animal Services could seize the cats, they violated the Fourth Amendment by using excessive force when they did so. She alleges the officers used something called a cat grabber, whatever that is, that injured and ultimately killed a calico. So in the attempt to seize the cats, one of the cats died. So this case involves Animal Services using a cat catching tool, whatever that is, to catch a cat, and this is kind of important, which according to indisputable testimony, looked ready to maul the cat catcher. The cat was a little aggressive. That the calico died as a result of this manifestly reasonable tactic is unfortunately, but not unreasonable. Yeah, so, the cat over here is ready to kill. So we used a cat catcher. Unfortunately, the cat died as part of the process, which is sad, but we had to seize the cat. We don't think leaving the cat in the home is going to fly. So, yeah. Okay. Yeah, no, Richard Lopez says you've been in a house with one cat. Can't imagine 37. Yeah, you've been in a house with one cat, presumably where the cat has a litter box. Have you ever been in a house with a cat where the litter box hasn't been changed in a while? Now, I'm going to take a guess. Which I think is probably pretty reasonable, that there's not sufficient litter boxes for 37 cats. And they're not particularly well maintained and not particularly emptied on a regular basis. I'm going to guess that there is feces and pee on the floor in some notable amounts. Yeah. Thus, this brings us to the end of the very sad case of Sally Gatjens versus City of Love Park. In this case, City of Love Park entered her house without a warrant. The court says exigent circumstances. I'm inclined to agree. They thought that there might be reason that she might be in there hurt, needing help. And what they found when they were in there, the 37 cats with the smells so strong that even brave men couldn't enter without respirators. And so she's upset that they seized the cats and that they condemned her house. And, I can't speak to this as an attorney, really, because I guess everyone deserves their day, and, if she's paying, I guess, but, my first thought as an attorney, if you come to me with this case, and maybe it says something about me, well, my first thought of it is, you need help. You need help. Your immediate problem is not the issue dealing with whether your rights were violated. Can we look past that issue into the you need help pile? Apparently not. So at least one attorney was willing to fight for her rights, which I guess there's something admirable in that. But yeah, your rights weren't violated. Maybe get some help. Maybe less with the 37 cats and conditions and the hoarding and stuff. So whether or not Sally Gatjens will take this as an opportunity, I don't know. But for at least the moment, that brings us to the end of the consideration of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.